Final case for this morning is case number 28661, in re the estate of Virginia Durkin. I notice that Attorney Lesich is here for the appellee and Mr. O'Halloran, is that correct?
Yeah, O'Halloran.
Okay, O'Halloran is pro se representing himself as the appellant, which is fine. The way the arguments will proceed this morning is that each party has 15 minutes to present their arguments. Mr. O'Halloran, you're the appellant, so you will have the opportunity to reserve up to 5 minutes max for rebuttal. If you want to do that, make sure you let us know at the start of your argument. You should know that the oral arguments are recorded and they are posted on a YouTube channel of the court. So both parties, please keep your voices up, remain behind the podium. The court has read the briefs that have been submitted in this matter, and we are ready to proceed if you are.
Good morning, Your Honors. My name is Daniel O'Halloran. As you mentioned, I'm a pro se appellant in the matter of Virginia Durkin estate. And I would like to reserve 5 minutes for rebuttal.
5 minutes, okay, thank you.
So really there's kind of 4 points that I'd like to focus on. The first was that I believe that the lower court erred by abuse of discretion when it did not remove John Durkin as executor or / fiduciary for the estate. And so some of the points that go to that matter, well, I filed a motion to have John removed, and in violation of the local rules as I understand them, there was never a hearing on this matter. Neither John or his attorney, Mr. Pleisic, ever revealed that John Durkin had power of attorney over Virginia while she was alive. This was only discovered later on as a result of subpoenas that were served on my behalf. At the August 1st hearing, John lied under oath about an IRA that the court eventually included in the estate. He said that my mother, Patricia O'Halloran, was never a beneficiary on the IRA and that his mother, Virginia, had made the transfer. When a subpoena came back with evidence that showed that he had used power of attorney to actually make himself 100% beneficiary, the court issued orders to investigate further, and when they did, they found out the original beneficiary was actually my mother, Patricia O'Halloran. So I think that's an important aspect. So, you know, he committed self-dealing with the power of attorney, and it's also important that he did to note that he did this in 2004, which was 11 years before my mother passed. The appellee brief tries to assert that this was done after my mother died. I think they were trying to make it seem more innocuous, but it was more than a decade before Patricia died that this change was done. Throughout the process, through his attorney, John refused to provide requested estate information to Daniel, myself, and given that he was a fiduciary before Virginia was deceased and after, he had an obligation to provide information that was requested. Also, as an exhibit from the United States Treasury Department shows, on October 5th, 2016, John made a direct transfer of estate funds to his own personal treasury account without permission from the court and without consulting with any of the other beneficiaries. In contrast, on March 24th, earlier that year, 2016, he cashed out about half of the bonds to an estate account. And if you look at the difference, for one thing, the bonds that he cashed out earlier in March were now no longer earning the high interest rate of the bonds. And he handpicked which bonds he cashed out to his personal account. He picked the ones that had the most time left to mature, the most time left to accumulate interest. Also, there's a discrepancy between the bond numbers held by Patricia and John, which is revealed it's kind of in-depth to look at, but basically, kind of the bottom line there is that more discovery is needed. And that's a major theme throughout my appellant brief, is that this case was not resolved. I was in the middle of discovery when it was closed, and a lot more discovery needs to be done. To that effect, I also provided evidence that John Durkin used power of attorney to close out $162,152.70 from Third Federal Bank, and the destination of those funds are unknown because I never got to finish the discovery process. The second point is I believe that the court erred by abuse of discretion by not removing Attorney Pleisig as attorney. On August 1st, he lied under oath about sending notice to the beneficiaries, myself and my two sisters, Kelly and Kathy, about the November 2nd hearing. We never received notice about this hearing, and we only discovered it when we went to try to hire another attorney. We believe this was an attempt to try to deny us the opportunity to bring up objections. Like John, he refused to provide information that the beneficiaries requested. Mr. Pleisig acted hostile and unprofessional towards myself in a phone conversation that I do have a recording of and could provide a transcript of, never got to at the lower court level. He called me a jerk and said I should seek psychiatric care, which I don't believe is the way an estate attorney should treat one of the beneficiaries of the estate. He filed 2 fraudulent motions for contempt, and I say they were fraudulent because, for a number of reasons, the court order that they derived from was issued ex parte, and then he didn't allow, well, the first one, I was never even served the order, and he was filing a motion for contempt, and he never retracted it. And then the second one, he didn't actually allow me enough time once I was served the invalid order to actually comply with the order. Mr. Pleisig spent most of his time as personal advocate for John Durkin, and most of his activities were basically revolved around concealing what John had, his misconduct, and not giving us information, and he wants to charge all that time to the estate. He committed fraud or material misrepresentation against third parties by sending unsigned court orders to PNC Bank and New York Community Bank saying that 2 subpoenas had been quashed. He did this before the court ever ruled, and the court then ultimately ruled that those motions were denied. And those 2 banks, because I called them, they took that as having the weight of the court, his unsigned court orders that he sent them. He also committed material misrepresentation against this court when he said that John changed the beneficiary status after Patricia died, when as I've already said, it happened 11 years before she died. He also committed at least 23 violations of civil procedure. Most of them were service violations, and that most of the documents throughout this case he never served upon Kelly or Kathy, who were parties to this matter the entire time. And you can actually verify that those service violations, because his own certificates of service do not include them and the people that he sent it. A few of the documents also arrived unsigned. A few of the documents never arrived. I never actually received the first motion for contempt in the mail. I only knew about it because I started keeping track of the online docket. The third point is that I think that the court erred when it said that all of the bonds in the estate were properly included, because per John's own testimony on August 1st, he understood Virginia's estate plan as follows. Any asset that would have passed to Patricia would instead go to her 3 children, Daniel, Kathy, and Kelly. As power of attorney, John had an obligation to preserve Virginia's estate plan. Per his own testimony on August 1st, he never consulted with Virginia. He never made any attempt to get the bonds retitled. By his inaction, he's benefiting by inheriting half of the bonds that were originally titled in my mother, Patricia, and Virginia's name. Furthermore, he was in sole possession of the certificates and the titling on these bonds. He never disclosed this information to Patricia, which he also testified at the August 1st hearing. So she never had her legal right to cash out these bonds because they were basically kept secret from her. And finally, I believe the lower court acted prejudicial against me. No sanctions were ever brought against John or Mr. Pleisic, despite the rules violations that I brought to their attention. In contrast, I was found in contempt for not responding to a court order that was signed ex parte. I was never given a hearing on the contempt, which I believe is a violation of my 14th Amendment right. The court blocked my discovery efforts. I filed a motion to compel, and they did not respond until they rendered their final decision 185 days later, which is a violation of the superintendent's rules, which said that they're supposed to respond in a timely fashion and they have to do it within 120 days. Also, the court refused to issue orders to see my final 2 subpoenas fulfilled, even though they denied Mr. Pleisic's motion to quash them. The court also violated its own rules a number of times. The original evidentiary hearing was scheduled for July 1st. Instead of an evidentiary hearing, it turned out to be a hearing between myself, Mr. Pleisic, and Magistrate Wirtz in his office, but it was not recorded. And it's my understanding of Ohio Civil Rule 53D7 and Local Rule 11.1A is that any meeting with a magistrate should be recorded. And it's important that it wasn't recorded because the magistrate was actually making excuses for misconduct by Mr. Pleisic, and at the same time, he was not giving me any guidance for how I could proceed on discovery.
Mr. O'Halloran, you have 4 minutes and 50 seconds left. You can continue or stop and then reserve this time for rebuttal.
So reserve it for rebuttal. Okay, I'll reserve it, Your Honor.
Okay, that's fine. Of course, you're welcome to continue if you'd like and use into that time.
No, that was pretty much where I was almost about done.
All right, we'll hear from you on rebuttal then. And
Good afternoon, I'm Michelle Morris.
good afternoon. You have 15 minutes.
Thank you. I am here on behalf of Virginia Durkin's estate with co-counsel Mr. Plessich.
Counsel, could you speak up a little bit?
I will
have
do,
a cold and unfortunately it's got my ears.
I can relate. So the case before the court, this is a fairly straightforward estate. The administration of the estate ended up being quite contemptuous, but it's really pretty simple. Virginia Durkin died testate, and she died on August 29th in 2015. Her will provided that her assets be distributed equally per stirpe to her 2 children, John and Patricia. Patricia had predeceased Virginia by 6 months. So the portion of the estate assets that should have gone to her went to her 3 children, Kathy, Daniel, and Kelly. The assets really at the time of death included an IRA naming John as the sole beneficiary, a joint with rights of survivorship bank account, and there had been CDs prior to her death that were cashed in equal proportion and deposited into the joint with rights of survivorship bank account to pay for the care of Virginia Durkin. There were also bonds. The bonds were properly in the estate. They were co-owned by Virginia and her 2 children, and thus when Patricia died, the bonds returned to their owner, Virginia, and so were properly distributed through the estate. So there was an evidentiary hearing that was conducted in the lower court. That evidentiary hearing, it was, I believe it was initially set for a hearing on the inventory, but based on a motion that was filed by Daniel O'Halloran, they converted it to a 60B motion and allowed Daniel to provide evidence to the court of what he felt were improprieties. So there was in fact a recorded evidentiary hearing that was conducted by the lower court. Ultimately, the court ordered that the IRA be distributed in the estate according to the terms of the will, because the court found that it was a violation for John to have changed the beneficiary designation on that IRA to himself. So the court corrected that by, excuse me, ordering that it be included in the estate and distributed in accordance with the will. The court affirmed that the bonds were correctly distributed in accordance with law through, that they were correctly distributed. And then the court imposed a constructive trust on 50% of the proceeds remaining in the joint with rights of survivorship account. And the estate did not take issue with that, although it isn't really in accordance with what the law provides, that account should have just gone to the remaining owner of the bank account. But that PNC joint with rights of survivorship account did not have a lot of money left in it, and as I mentioned, the money that was in there had been utilized for the payment of care for Virginia. So the Daniel Halloran raises several issues as assignments of error. Basically, they fall into three general categories. One is with regard to the assets, which I've already discussed, and then there's another area about the removal of the fiduciary, the removal of the attorney, and the removal of the court. And with respect to the removal of the fiduciary, there before the court was no evidence of any fraud or misconduct by the fiduciary. Likewise, there was no evidence of any misconduct by Attorney Plessage. In fact, although appellant argues that there were several inappropriate filings and signatures and these types of things by Mr. Plessage, the docket itself will reflect that Mr. Plessage's filings were all done timely and in compliance with the rules. And of course, the argument that the court should have recused itself is not something that's properly before this court, because this court would have no jurisdiction to rule on that. If it was in fact properly raised below, it would have been brought before the Ohio Supreme Court with an action to ask for the court to be removed. The other area is the argument about the discovery issues, and that discovery, the appellant is arguing that he wasn't permitted to conduct discovery, but as the docket reflects, there's just simply no merit to that argument. Mr. O'Halloran was perfectly at liberty to conduct discovery according to the rules as anyone else could conduct discovery. He did not do that. He instead filed, at some point in time, he filed a motion attempting to obtain what he characterized as all relevant evidence to the Durkin estate. That motion was overly broad and didn't comply with any of the discovery rules. And also, likewise, he issued in excess of 45 subpoenas to banks. He did not ever at any point, even to this day, and in the face of a court order, ever provide copies of any documents that he procured as a result of those subpoenas to the estate's attorney. So the appellant is arguing that that it was error when the court below did not afford him the opportunity to conduct the discovery. It was error for the court to find him in contempt of court, but in fact there's just no support in the record for those allegations. He did issue a number of subpoenas. He never provided opposing counsel with any copies of any documents that he received from a result of those subpoenas. The court itself ordered him to provide those copies. He flagrantly disobeyed that order. The probate court in its final appealable order specifically indicates that it did not hold appellant in contempt. It simply allowed Attorney Plessage to recover additional fees for having to contend with the motions he filed to try and get copies of those documents. And it's also worth adding that the court sua sponte issued subpoenas to the banks to get the information it felt was relevant to determining what went on with the IRA, and it did receive and file the documents that it receives as a part of the docket. part of the record, and then as the order reflects, that the proceeds from the IRA were ordered to be distributed through the will rather than the assets going to John Durkin. So the estate is asking the court to affirm the lower court as the errors raised by the appellant are without merit.
Any questions? No? Very good, thank you. And Mr. O'Halloran, I'm sorry, you have 4 minutes and 50 seconds left for your rebuttal.
Thank you, Your Honor. First off, unfortunately, it was not a simple estate matter because my uncle, as I said, had power of attorney, and all evidence points that he was abusing that power of attorney before Virginia died. And I believe it's only the tip of the iceberg of the evidence I've discovered so far. We have large sums of money that we have no idea where it went. The other side makes claims that all this money was used for her care, but never provided any evidence to support that. As a power of attorney, it is your responsibility to prove that your transactions and to disclose your transactions to the other party. I asked for that information. I followed all the discovery rules. It's also worth pointing out that all the arguments they've made today, they never brought up at the lower court level. They never filed objections to any of my motions. So all of their arguments should not be preserved for appeal, if I understand how the rules work correctly. Yes, all their arguments are new, basically. Whereas everything I'm talking about is stuff I brought before the lower court. There was an evidentiary hearing, but then there was new evidence, in fact, significant evidence after that evidentiary hearing. There should have been a further evidentiary hearing. It doesn't matter if there was one evidentiary hearing. If there's new evidence, there should be a new hearing. And I never got that hearing despite requesting it. They're also the court somewhat recharacterized the whole contempt thing. They did find me in contempt, and even the appellee writes this in his own brief. He says in one paragraph that the court finds me in contempt, and in the next paragraph he says the court did not find me in contempt. That just makes no sense. They found me in contempt, and then they tried to recharacterize it to get out of the fact that they violated my 14th Amendment right and never gave me a hearing. I mean,
What was your consequence for the contempt?
a $500 fine.
Thank you.
Yes. And as far as the court order itself, the reason I didn't comply, I made a good faith effort actually when I filed these subpoenas. I asked the court, I sent a letter when I sent the original subpoenas because I had to send the subpoenas to them to get to certify. And I said, please let me know if I need to serve these upon Mr. Plysick, because it was unclear to me from reading Civil Rule 5A and Civil Rule 26, I think A, about privacy of discovery. It's like, I'm not sure, am I allowed to issue subpoenas without telling the other party or not? It was not clear to me, and it's still not clear to me, and I'm sorry if I don't understand that exactly. I get the impression that yes, I should have probably served him with the subpoenas, but I'm pretty sure that he has no intrinsic right to the responses to the subpoenas until I decide to bring them into a filing or into court. And so that's why the court order was invalid. It was not simply a matter of law. It was executed ex parte. I was never given a chance. It was literally signed the day after it was written, before I had even been served the motion itself. So, I mean, numerous rules were violated. I wasn't given the opportunity to file objections. It was an ex parte order. So, you know, I mean, how was I supposed to respond to it when I never even got my chance in court to talk about it? So, I mean, they would like you to believe, and they would like it to go away because they're trying to cover up significant misconduct by John Durkin, and Mr. Plysick has participated in that conduct and helped basically conspire to conceal that misconduct, which is a serious offense. Basically, I believe this should be, I guess, remanded to a lower court. I'm hesitant to go back to the same court because, as you may have read in the brief, I really have little faith that I'm going to get a fair hearing from the same judge and from the same people. If it could be remanded to the General Common Court of Pleas or something else, I would be in favor of that. There are a lot of unresolved issues. There's a lot of discovery that needs to be finished. They haven't proven most of their claims. They claim all this stuff was used for Virginia's benefit. They never provided any evidence to support that. And even though it wasn't evidence that I got before the final decision was rendered, one of the banks actually did respond to the subpoena, and it showed another $270,000 in withdrawals from Virginia's account in very large sums. What were those sums used for, and where did those checks go? I'm very suspicious, and I would like to know where those went, and I have a right to know because John Durkin was power of attorney for Virginia while she was alive.
Mr. O'Halloran, with that, I'm afraid to indicate that you're up with your time is up.
Thank you,
so
sir.
I want to thank both parties for the presentations today. The court will take your matter under advisement, we'll discuss your case and issue a decision. In due course, the court will mail a copy of this decision to each of you on the day it's released. Also, the opinions are posted on the Supreme Court's of Ohio's website. The court is going to be adjourned until January 9th, Tuesday. And